A very good afternoon to all present. On behalf of the Research and Development Cell and the Institution Innovation Council of Sri Guru Gobind Singh College, Chandigarh, it gives me a great pleasure to welcome you all for today's session on Intellectual Property Rights Awareness Programme. Am I audible to everyone?
Yes, ma'am.
Yes, ma'am. Okay. We are honored to have with us today Ms. Anumita Verma, Examiner of Trademarks and GI, Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, Government of India. She has done BA LLB Honours from Jabalpur and joined Central Services in 2017. Ms. Anumita is highly experienced and respected professional in the field of intellectual property and has extensive knowledge and expertise, particularly in trademarks and GI. Ma'am, we welcome you. I would also like to extend a warm welcome to my worthy colleagues and dear students. Intellectual property rights refer to the legal ownership and protection of creative works such as inventions, literary and artistic works, symbols, designs, and trade secrets. The primary objective of IPR is to safeguard the interest of the creators and innovators by granting them exclusive rights to use and exploit their creations. In recent years, IPR has gained significant importance due to the increasing pace of technological developments and the rise in global trade and competition. To educate the public, especially students, researchers, entrepreneurs, and businesses about the importance of IPR, their legal provisions, and the benefits of obtaining protection, the Office of the Controller General of Patents, Designs, and Trademarks has launched the National Intellectual Property Awareness Mission, NEPAM, under which awareness has been imparted to 1 million participants on intellectual property rights during 2021 to 2022. Now, the second leg of this mission, NEPAM 2, has been commissioned from 16th August 2022. The session organized today is an endeavor to promote the use of IPR as a tool for innovation and creativity. Through this program, participants will gain knowledge on how to protect and manage their intellectual property, avoid infringement, and resolve disputes related to IPR. Before we start the session, let me give a brief introduction of our college to the guests today. Sri Guru Gobind Singh College was the first co-educational institute established in Chandigarh in 1966 and has a distinguished legacy to its credit spanning more than 55 years. The college has accomplished notable achievements under the leadership of our principal, Dr. Navjot Kaur. Her dynamic vision and able leadership is what propels us forward. Ma'am has an illustrious career spanning more than 25 years. She has authored books with international publishing houses and written several research papers for reputed journals. She has also been a member of advisory board, editing and reviewing committees. Before taking over the reins of the college as principal, Ma'am has held several administrative and leadership positions. I welcome Ms. Anumita and invite her to present her IPR Awareness Programme. I am sure our faculty and students will be motivated for the creation and protection of intellectual property with her valuable insights. Before we start, there is one request to all the participants that if the meeting ends abruptly, kindly rejoin the session using the same link. Secondly, the feedback forms will be shared at the end of the meeting and e-certificates will be issued based on that. So you are requested to fill the Google Forms when the meeting is ended. Thank you. Now I invite Anumita ma'am to start her lecture. Thank you. Anumita ma'am, your video and audio are not coming. Please check it. Your voice is also not audible.
Can you hear me now?
Yeah, it's audible.
Okay.
Yes,
Okay.
yes. Now you can start your lecture, ma'am.
And is my video?
Yes, that is also visible.
Okay. Okay.
Ma'am, now it's gone.
Okay.
Ma'am, kindly share your screen.
Yeah, I'm sharing my screen. Can you able to see? No.
No, it's blank.
Just a second. Give me a second. Sorry.
Ma'am, your voice is also not coming and your screen is also not visible. I think there is some technical issue. Students, you are requested to bear with us. It will take a few minutes for Anumita ma'am to start her.
Yeah, please give me a second. There's some technical issue. I'm not able to share the screen. Just give me 1 second, okay?
Yeah. Yeah, now it's coming, ma'am.
Am I audible now?
Yeah.
Okay. Okay, good evening everybody. Thanks for having me here, ma'am. Thanks for giving this opportunity. So I would like to give you a brief overview of IPR. I'll be touching upon each IPR and giving you overview of each IPR. So firstly, we talk about little about NEPAM. So our IPR policy came in 2016, which was a 7-pointer policy, and one of the pointer being awareness. So this NEPAM mission is under that only, and we already had one NEPAM one. This is the second leg of NEPAM sessions which we are having. So this is a pan India mission where we try to, or which we aim to inculcate the culture of IP at the level of schools, colleges, university, and to tell them how they can commercialize their IP if they make one. And it's, the entire ecosystem of IP has a very strong role in the society, which needs to be told to the younger generation of the society. This is gonna be a little interesting lecture on that. So let's see what is the property. Property is either tangible or intangible. So tangible property which can be seen, felt, touched, or intangible properties which cannot be seen, touched, or felt. There comes the value of, or comes the thing of intellectual property. So what all intellectual property we have? We have patents, trademarks, designs, copyright, then your integrated circuits, then your geographical indications. These comprises of your intellectual property. So I'll be sharing my presentation after this with you. So you don't have to note down anything or something like that. Just listen to me properly so that you can ask questions after this session. Okay. So then you just see all of these are our intellectual properties. And then we'll quickly move to the trademarks first. So what is a mark? A mark can be anything, which is a device, label, heading, ticket, or or whatever the goods packaging or combination of color, etc. But now what trademark is? So trademark, as per definition, I'm not going too much legal here, but still I'll tell you a brief description. Trademark has to be graphically represented. That's one condition of trademark. And mark being anything, if as you see in the section 21M of the Trademark Act, and it needs to be distinguished from the goods and services of one person from that of another person. Why am I saying that it needs to be represented graphically? Because, for example, these days a lot of academics and academicians are talking about smell trademarks. So we cannot have it right now here because we cannot give them a graphical representation. So it is very important in a trademark to be graphically represented. This is the basic meaning of the trademark. Then, if you talk about, you supposedly you open your business after your college, or if you join any company wherein you have to suggest any good trademarks or something. So there you can suggest these marks as very as a strong trademarks or maybe weak trademarks if you know the meaning of the trademark. For example, we see the trademark in if it is non-distinctive, then of course it is a problem. It does not get registered. So you have to see the distinctiveness of the trademark. So how we derive to the distinctiveness? We have some 4-5 categories of trademark, which is nowhere mentioned in the Act though. It is given by the Honorable High Courts and Supreme Courts of India. So first is fanciful or coined or invented word, wherein you join two words together and then you have a new name. For example, codec. It has got no dictionary meaning, yet it is a coined word or fanciful word wherein you have joined co and dac together. And that's a very strong trademark. Recommended. It is a very strong trademark. Then you have a generic trademark. So generic trademark is, as it tells you the genesis of the product. For example, aspirin. So it is highly descriptive for pharmaceutical industry. So it is not that strong a trademark unless it acquires the secondary meaning, or it is known by the, for example, you go to the medical store and says that, just give me one Disprin. So even if you are having headache and you're taking some other medicine, but you ask for Disprin, he will give you some medicine. So that is acquired the secondary meaning. That it is, for example, Colgate. You do not say that, please give me. Hello?
Excuse me, ma'am.
Yeah,
Yes.
yeah.
One thing is, please turn on your video. And second thing is, your slides are not changing. It's stuck on the first slide itself. Can you please change the slide?
I am doing it,
full screen and make
Madam, I'm doing it, but I think there is some problem. I don't know what.
Yeah, it is stuck on the first slide itself. It's not going ahead.
Is it?
And second thing is, make it a full screen.
Yeah, I have made it a full screen, and there's some technical problem. I don't know what's wrong here. So, can I share the presentation with you so that you can share it?
Okay, ma'am.
That would be okay with you. Just a second, I'll share it with you. Give me 1 second, okay?
Yes, ma'am.
Ma'am, can you hear me now?
Yes, ma'am.
And I've sent you the presentation. Can you please share? Because there's some issue. I'll manage with my
And have you mailed your presentation or where did you send it?
over your WhatsApp.
Okay, let me check it now. Right, ma'am, you can start now. Wait. Let me start your PPT and then.
Okay, I'll take up from the.
Ma'am, can you mail me this PPT?
Now please check your email. Sorry for the inconvenience.
Received yet. I haven't received yet. Okay.
Ma'am, please check. I've sent it from my Gmail account.
Ma'am, I have checked it and didn't receive yet. Yes, ma'am. Now you can start.
Have you received it, madam?
Yes, ma'am. I'm about to share it. About to share. Yes, ma'am. Now you can start.
Okay, thank you. So can I start from the first thing or
No. You start from where you left.
Okay.
Tell me the slide number.
spectrum of distinctiveness, slide number 8.
Okay. Yes, ma'am.
Okay. So I was talking about the how strong the trademark should be for your for the registration. So I already discussed the fanciful one and the generic one. So we'll go through quickly for third one, that is suggestive. Suggestive means it should not be suggestive like at glance for calendars. That's the example, because you exactly know that we are talking about the calendars. So that is still a better one than the descriptive one, but still you have to think through for this to reach that conclusion, that we are when we are talking about ad glance or calculus. Then we have descriptive ones, which means quick print, for example, quick print for printing. That is like highly descriptive, and it is, of course, it is it comes under the purview of Section 9, which is the ground for absolute refusal under Trademarks Act. So these are the basic, spectrum of disciplinars for any trademark to be to get registered or not to get registered. So, ma'am, can you please, yeah. So this is a section 9. I already talked about distinctiveness. Then we have this. These are the absolute grounds for refusal under section 9 of the Trademark Act. So section distinctiveness I've already discussed. Then we quickly go to section 9(1)(b), which talks about if the trademark describes the kind, quality, quantity, intended purpose, or geographical origin, then of course it is not registrable. So what do you mean by kind? If you talk about kind, then you can't say that kind for example garment. If you're saying the XL, so that is the kind. So you cannot get registration for your garment product if you're saying that my trademark is extra large or small for your clothing brand, maybe for a clothing chain. Then you have the quality. If you're talking about supreme, best, something of that sort, if you're using that kind of trademarks, then again this will attract the objection under section 9. Then if you talk about quantity, then for example, if you're selling wine, the case of or numeral number 12, if you use as your trademark for you're selling the wine, then it is of course descriptive, because you're telling the quantity of the case of the wine. So that is how it is. And then the intended purpose, if you're telling the intended purpose of your services or goods which you're offering through your business outlet. So for example, cuts and curls for salon services. It is highly, you're telling the intended purpose of your goods and services. Obviously, then you have the value. It should not indicate the worth or the merit of or importance of goods or services. So that is the value of the goods. It should not tell the value of the goods. Then you have the geographical origin. So for example, Japan is famous for fish. So you cannot use your trademark. If you're selling fish, then you cannot use your trademark for this. And that is of course objectionable under section 9 of the Trademark Act. Then section 9(1)(c) talks about the customary, if it is customary in the trade. For example, your incense sticks. So if you say you're selling incense sticks and your trademark name is jasmine or rose, so it is very common, it is very customary and in that particular trade. So you cannot, of course, not have it. And then I quickly move to section 9(2), and I will not be going into the into these sections because it will take a lot of time. So I'll just quickly say that if it is the public, for example, if you're selling clothes of cotton and you're saying that your mark is wool wala, then definitely it is. This comes under section 9(2)(a). If you talk about it should not hurt the religious susceptibility of any section or any religion of this country. If somebody is using gods and god and goddess pictures on a footwear, it is of course objection under section 9(2)(b). Then it should not contain scandalous matter or obscene matter. And then lastly, it should not be prohibited under the Emblems and Emblems and Names Act, Prevention of Improper Use Act 1950. So all the trademarks which shows the patronage of Government of India, it is those kind of trademarks attracts objection under section 9(2)(d) of the Trademark Act. Next, I'll quickly move on to how you file the trademark, because it's very important for all of you. If you're going to file the trademark, if you want to file, then you have to be applicant. Applicant could be a company or a single individual or a partnership firm or even startup, which has come recently. For startups, we give a fee concession and For that, you have to acquire a certificate of recognition from DPIIT, and you get fee exemption of 50% for that. Then you have if you're a company or a partnership firm or an individual, definitely you can come and file the trademark. Jurisdiction you have to see, because the offices is in trademark offices in we have 5 branches: Bombay, Delhi, Calcutta, Ahmedabad, and Chennai. So states are divided accordingly. For example, for Chandigarh, it is Delhi. You can file it in Delhi. The jurisdiction would be Delhi, and then you have to pay the appropriate fee. So the appropriate fee would be, for applicant, it is online filing. For if it is an individual, then it is 4,500. Otherwise, it's 5,000. So we give 10% exemption on online filing, because we encourage online filing and all of that. So if you're a company or a partnership firm, then it is the fee would be 10,000 for physical and 9,000 for online filing. But if you have a certificate of MSME, then being a company or a partnership firm, then the fees would be 4,500 and 500 respectively for online and offline filing. So, and see, all the goods and services which we have here are divided into 45 class as per Trademark Act, or we follow one lease classification for that, sorry. So, and accordingly you file your trademarks. For example, if it is cosmetics, then you file under class 3. So, for example, Lakme for cosmetics will be filed under class 3. Any pharmaceutical company, Cipla or whatever, they will file their application under class 5. So, like that. And if you're using your mark since, say, 1980 or 1990, then definitely you can claim the user and just give us one user affidavit, and then accordingly your because user is very important in trademark. And if you have a legal battle, or if you want to prove your use it since long, then it is a very important thing in trademark. User is the most important thing. Next, we have the other nuances of filing could be, we quickly see ma'am, please can you shift the slide? Yeah, just skip this. This is because I've already covered this. Yeah. Now we have this. We talk about this section 11, which says that if we have identical mark or a similar mark in our database, then definitely we are not giving you the mark, unless for identify, say that identity, if I say it means Anumita Verma and Anumita Verma is of course identical, and if I say Anumita Verma and Anumita Sharma, that could be similar for that, or ABC or ABCX. So this is similar. So if we have these kind of marks in our database, then we would not be giving you the mark, unless if you're dealing with a different set of goods. For example, I'm selling shoes and you're selling chemical. So of course, if there are two different classes, then you can have it, unless it's, and if it is a well-known trademark, then definitely you cannot have it. Next we have next is the filing fee, which I've already told you. So we'll quickly move on to the next slide. So we also see these, what is our basic requirements. I've already told you the name of the application, applicants, the way email ID, the principal place of business, address for service. It is very important for international trademarks, because if the address of service is not there in India, then they cannot file. Then there are type of trademarks, the device, where you have seen we have seen the logo maybe of Coca-Cola or anything. That's a label or device mark, and word mark could be anything which is written as ABC in normal letters or in normal this thing. That is your word mark. And if you want to see the further information regarding that, you can obviously visit our website. So this is a little examination process of how we do examination. So as soon as you file the application for trademarks, we examine it under the section 9, 11 and what all I have told you in the earlier slides. If it is acceptable to us, then we accept it, and the mark goes to the publication performance and it gets registered. You get the certificate for registration. If it is objected, then the reply to the examination report is seen and analyzed, and if it is okay, then we accept it and the same process follow. If not, then we set the show cause hearing, and likewise they also accept it or refuse it, and then of course it goes to publication and then the registration. And if there is no opposition within the period of 4 months, then it gets registered after the journal publication. Then we have industrial design. That's our next IPR. So industrial design is what? It is the ornamental or aesthetic part of any article. For example, you can see the Coca-Cola bottle or this car or the phone. See the design of these articles. This is also registrable under Designs Act. So you give us the drawings in 3D or 2D, whatever the shape is. You give us the drawings, perspective view, rear view, front view, back view. We analyze it and we gives you the design under this Industrial Design Act. It is for 15 years. Initially, you can get it registered for 10 years and maybe it is extendable for 5 more years. And then we have the integrated circuit layout design. So this IC is also registrable under IC Act. So you know what IC is. It is there in the phone. It is there in your computers. So it is also registrable under this. It is for 10 years from the date of filing. You can get it registered. Then we come to this very interesting topic of copyright. So what is copyright? I think you all know what copyright is. Copyright is the artwork, is the work what you create. So it could be anything, literary or your artwork or anything. So it is basically it is an inherent right. It does not require registration though, but it is bestowed automatically when you create it. When you create the work, it is yours. But it is highly recommended to have your registration because that gives you the evidentiary proof and safeguard your any claim of infringement if you have any copyright infringement in future. So it is highly recommended that you please get your copyright registered. Next we have, so what all kind of works you can get registered? Literary works, your books, your articles, maybe essay competitions or any database you have. Then your dramatic work, screenplay, play, choreography, script, anything, this comes under dramatic work. Then software works, your source code and object code. So software has source codes and object code that is registered under software works. So you have seen that C in the software this thing. You must have read it somewhere. Then you have the artistic work, your painting, diagrams, maps, charts, everything is registrable under copyrights. Then your musical work is also registrable. Your sound recording and cinematography, this is all registrable under Copyright Act or copyright this thing. So what all you need for copyright registration? So you need to, we have little prerequisites, ma'am, please next slide. You have little, you need to, file in under the form 14 before the registrar of copyrights, and it must be signed by the applicant. It must be made. The copy must be made for one work only in one application. Then of course you can have multiple applications, but in one work there's only one application will be entered in for that. And then, like I told you, this is literary software, dramatic asset, everything is registrable. Then you have what is the term of protection of copyright for literary work, and for literary work, it is the lifetime of the author until the 60 years from the death of the author. Then for anonymous, pseudonymous work, and your government work and public undertakings work or work of international organization, and sound recording and cinematography. All of this has the validity of 60 years from the date in which the work was first published. From that date, it is 60 years. Then you have broadcast and reproduction right. For example, it is 23, you got this thing. Then from 2024 and up to 25 years. Likewise, performance right is 50 years. So supposedly you have your work today, then you can use it from 24 till 50 years. That is the validity of your performance right trademark. This is the fee schedule. It's for literary work and your artistic work, software and music work. It's just 500 rupees. For artistic work being used in relation with goods and services and sound recording, it is 2000. And we have the abbreviation of that, so you can use it when you fill the form. It is there, so you can decipher like this from this. And cinematographic film is 5,000 rupees. Now, how do you register the trademark? Your copyright. The main, as soon as the application is filed before the registrar, it is just published in the journal for 30 days. We wait for the 30 days. If any opposition is there from the public side, Then we entertain that, we see what is to be done to that, and if not, it is sent for the examination to the examiner, and if examiner doesn't find any discrepancy, then it gets published and you get the registration. And if not, then it goes for we issue the discrepancy letter. For that, you have to reply in 45 days. And please remove the discrepancy and come to us. We'll see it again, and then the deputy registrar will see and grant you the registration. This is the simple process of corporate registration. The next, our next IPR is geographical indication. What do you understand by geographical indication? Indication, it means this is indicating towards something. So indication is a sign. So it is related to particular geography. For example, Banarsi Laddu or Banarsi Sari or Tirupati Laddu. I'm so sorry for Banarsi Sari or Tirupati Laddu. So it is telling the geographical origin that it is so unique that it is there in that particular geography. So we give the GI tag for that under the GI Act. So it has to have some reputation due to that origin. That's one thing, that it has to be unique. We need map for that. We need specification or some affidavit, the name of the Gujja class and method of production. So we require all of that. The form for that is GI 1A, 1A form, and it is from 1A to D. There are 4-5 forms, and the fee would be 5,000 per class. And then what all are the types of GI? So it could be handicraft, food items, your industrial goods or agriculture products. So a few examples: handicrafts are your Madhubani paintings or Mysore paintings or Tanjavur paintings, and food items could be Tirupati Laddu and Bengal Rasgulla. And then for example, wine and drinks, example is champagne, cognac. These are registered as GI in France. Then you have industrial products and the agriculture product, for example, basmati rice. So these are the products. See, this is the next slide where you can see a few examples. Yeah. So these are all the some of the GIs which have been given. It's there and are detailed in our website. Next is, we will quickly move on to patent. So what is patent and why it requires to be registered? You know that it is the monopoly right granted to the inventor. One who invents, it is granted to that, or his assignee by the government for the exclusive use of invention. This for the period of 20 years, and patent protection means invention cannot be commercially made, used, distributed or sold without the patent owner's consent. So patent, ma'am, please next slide. So patent, what are the requirements for that? So there is a problem. Now please click. Yeah, there's a problem, then you have a solution, and then you have invention. And when you have invention, then it is patentable. And when it is patentable, so what all are required to have a patent? It needs to be novel. You need to have inventive steps for that, and it has to have industrial applicability. Ma'am, please next page. So if these are the patentable subject matters, you can see any article or machinery or its component, any substance, whether living or non-living, can be or any product, pharmaceutical products, that can be patented. Any composition of matter, pharmaceutical products, that can be patented, and process can also be patented. Then we have an innovation cycle, how it goes. The idea came into your mind, then you did ma'am, please click. Idea came into your mind, then you did your prior art research, that what all is required, then you did your all R&D, and then innovation came. And when innovation is there, then you obviously would want to commercialize it so that you can earn something out of it. Then what is the criteria of patentability? Any product or process that is novel, inventive, which involves inventive step or has industrial capability, then it can be patented. And it should not cover under section 3 and 4 of the Patent Act, 3 being the frivolous patents and 4 being the atomic related things. So, can we use a combination of documents of attacking novelty? So, when we say new, or it is novel, it has to be new. It should not be there in the market. It should not do any cosmetic changes, anything. You say this is a patent, this is a new invention, that is not possible. So, This is a question of obviousness. Obviousness is a question which is involved in the inventive step, if it is inventive or not. So we'll see that. Next is, when you talk about inventive thing, then it has to be non-obvious. Non-obvious is something which we can see in the next slide, which requires your inventive steps to be non-obvious. Ma'am, please, next slide. Yeah. So if you can see this device, ma'am, click. Can you please see this device? It has 4 parts. One is the water containing portion, and 2 is your handle, 3 is your lid, and 4 is the spout of your cattle. But if you can see, if you combine together the part A and B, then you can, or maybe there's like A has 3 elements, then B has 2 elements, and then the D has some 2 elements. So if you combine these 3, then of course you can have the same result. So that means that it is not novel. If independently you see A, it is novel, it is new. If you are combining 2, 3 things and you are getting the same results, then it is not new. So that is not invention. Then I told you, like section 3, it's in the next cell, it should not be frivolous or contrary to the law and morality or injurious to public health. Then it cannot be patented. So, and next is who can file the patent? A true inventor. If it is your invention, please you file the patent. And the signing of the inventor. Any natural person can be a signee, or any legal entity can be the signee. Then this is the territorial jurisdiction for filing the patent for Mumbai, Chennai, New Delhi. For ma'am, please next slide. For Chandigarh it is New Delhi, so that is there. So if you want to file the patent, you can file in this office. Next we have the documents which are required for patent filing. Basically, you need a covering letter, then an application form, form 1. Then if it is a foreign filing, then form 3, proof of right, prescribed. Proof of rights in case the inventor is not applying, somebody else is applying, the assignee is applying, for example. Then proof of right, any assignment deed or anything is required. Prescribed fee, patent specification and declaration as to inventorship. Extract and drawings and etc. And if it is filing through the attorney, then the power of attorney is also required. We have a e-filing system which is very easy. You can file it either physically or through e-filing, where you can see there are the forms. And next slide, I can show you the forms. What all forms are required? Yeah, these are the forms which are required for patent filing. For application, of course, form 1, and rest is for other forms. The rest are the other forms which are required for other purposes. Then there is the fee for patent application. If you are an individual, the fee is 1600. If not, then it is 8000 for each priority. And you can make 10 claims in one form, and 30. It has to be till 30 pages. If it is beyond that, then 160 rupees extra for individual and 800 for the other entities. And in case the claims are extra, then more than 10, then of course 320 for an individual and 1600 for any other entity. Then processing of a patent application is, as soon as it is filed, then it is published, then it is examined, and then they wait for the any pre-grant opposition. If there is any opposition to this, then they of course appoint the hearing, and the process goes like that. But if not, then they grant the patent, and if they give the hearing, if there is any opposition, and if the prosecution is successful, then they grant it, and it is subject to the renewal also. It can be renewed, and maximum is for 20 years. So this is the further information is there in our website, and this is the WIPO website where you can see the international filing for patents and etc. If you want to see for others, then it's also there in the WIPO website. Thank you so much for patiently listening to me, and you can ask any question if you want.
Thank you, ma'am. This presentation really sparked a lot of interesting ideas and information. I'm confident that we all have benefited benefited from your insightful deliberations. Now the session is open for questions from the participants. Before that, please, the Google form is shared in the chat box. Kindly
Hello.
fill that form. Only then the e-certificates will be issued to the participants.
Hello.
Hello. Yeah.
My question is regarding novel inventions. You said that there can be only novel inventions if we are able to, produce something new. But if something that is already in the use and it has been used in a different or novel manner, so would it that be
No,
considered?
no, that is not allowed. If it is used for different thing, for example, a malaria drug, it is already existing. If you're using it for something else, then it is not an invention. And it's not allowed. It's allowed in US. It's not allowed in India.
If something new comes out of the product, like if we are using a specific
Adding something to it and then having it purified, then it is there. Then it is okay, but it should not need VC for this thing. If you're using it is available in 4 platforms, then of course it is not novel. Like we have searched, we search in the normal Indian perspective and in the global perspective. If we find it anywhere, then it
my,
is not novel to us. If
actually
you're
my
adding 1 and 2, one is existing. If you're adding 2 to it and you're saying that my product is novel, so we'll see if it is there in India or it globally. Then only we can give you. Otherwise, it's not novel.
No, my concern is actually regarding to refinement. If certain particular instrument, like if we get
No,
a take
refinements are not patentable. It's not there. It's not there.
any, no, no, not in the sense of like if there is something that comes out of the product as a new thing, which is not being
Byproducts.
yes, any particular product, like if it's an instrument, like there is a drum set. We take about talking about drum set, then it is a mesh of different instruments, so that becomes a new product. So if it's a
If
mesh.
you can prove the novelty of that product, then it is course it is. Otherwise, it is a byproduct, so it would be considered a part of the invention. So the old invention, then it won't be novel for us. If you can prove the novelty in it, because to me it is not novel.
Okay.
Yeah. Any cosmetic change or any subtraction addition, if you're doing and you're saying my invention is new, no, it's already there in the public domain. So then no, it is not possible.
Any other question?
Feel free to ask. Ma'am is not going to punish you.
No, ma'am. Anyone who wants to ask any question from ma'am? Any queries?
Ma'am, I have one query.
Please.
Ma'am, like you tell about the product that we need patent or registration or any copyright. Does it apply on the things like watches or does it not? The watches including that?
I can't hear you. I think you're somewhere out. Can you please repeat it? Repeat, am I audible?
Harpreet, can you repeat your question?
Please lost the connection.
Ma'am, am I audible?
Yeah, you're not. Yeah. Can you please repeat your question?
Yes, ma'am. Ma'am, like I was telling, ma'am, you told about the products we need copyright or patent if we are an inventor or innovate something. Does that rule apply on watches too, or that comes in a different category?
Watches.
Yes, ma'am, watches.
Watches for watch, you cannot get any copyright. I believe for the literature of the watch, you can get the literary work. For any logo if you're using on your packaging, then you can get the trademark done. And for the technology which is used in the watch, of course, it can be patented if it is new. Whoever got the watch, whoever has invented the watch has already gotten the patent for the watch. So, of course, it is patentable. It's a product, no? Product or process can be patented.
Any more questions? Okay, now I invite Dr. Kuljit Singh Chakkal to present a vote of thanks.
Thank you, ma'am. Good evening, everyone. Good evening, ma'am. On the behalf of the organizing committee, and am I audible?
Yes, sir.
Hello.
Sir, can you switch
So,
on
good
your
evening,
video?
everyone. On behalf of the organizing,
Sir, can you turn on your video?
yeah, sure. Is it okay now?
Yes, sir.
Yes. So, good evening, everyone. On behalf of the organizing committee and the participants of this IPR Awareness Program, I extend my sincere gratitude to our esteemed resource person, Ms. Anumita Verma, for sharing her valuable insights and knowledge about the intellectual property rights. Ma'am, we appreciate the time and effort you invested in sharing your expertise with us. Your informative session has provided us with a deeper understanding of intellectual property rights and has contributed significantly to raising awareness about this crucial subject. I also extend my thanks to our respected principal, Dr. Navjot Kaur, and the college management for providing constant support in organizing this event. Lastly, I would like to thank all the faculty members and students who participated in the program and made it a success. I again request you to kindly fill the feedback form for your e-certificate generation. Thank you.
Thank you so much, sir.
Thank you, ma'am. Your lecture was really very interesting.
And I'm still open to questions. If you can have any questions, you can send me via email also. Ma'am, I'll be sharing the presentation, the other one with you, with little changes. And you can share it with the students, and that has my email ID also. They can write to me if they have any questions.
Right, ma'am. Thank you so much.
Thank you so much.
Thank you, all the participants. Thank you.